let's just start. So the first thing that I want to tell you when we're doing this is you need to make the objections the defendant's fault, not their lawyer's fault. It's very easy to get personally involved with the defense lawyer who's being a jerk and make it personal about the lawyer. All of my letters setting up my motion to compels are assuming the lawyer is trying to do the right thing. And by that, I mean, I understand that you'd want to follow the rules of civil procedure and eliminate some of these things, but the corporate counsel for your defendant or your client is refusing to provide you, or your client is refusing to assist. If you need any personal privilege, any personal courtesy, please just let me know, and I would be more than happy to assist you. Should I not hear from you, I understand it's not a personal problem, and this is something that's client related. Now, the beauty of this is you get to go first, and you say, Judge, the one thing that I'm happy about is if there had been any matter involving the attorney, involving any of his circumstances, we would have worked that out. This is a client related problem. I'm sure the learned defense counsel won't be able to tell you that because of attorney-client privilege, but this is really a client problem, and the defense lawyer is going to need your help, Your Honor, to corral his client. Otherwise, we're all going to be in the same mess. We're going to be back here a bunch. So make it the defendant's fault. The defendant is not going to the same country clubs as the lawyer. Their wives aren't in the same schools and bar associations. They don't travel together. They don't have the old firm ties. There's a lot of reasons that if you make it about the client, you'll come out ahead. If you make it about the lawyer, you're not going to have the results that you likely want. Additionally, you should always take a look at the federal law in your state. The reason being is every state looks at the federal rules of civil procedure if they're substantially similar to the state counterpart. It's persuasive, not mandatory authority, of course, but if you cite the state case saying that we adopt the federal rules of civil procedure as substantially similar, then you can dump in all of the federal rules, and the federal judges and magistrates are far more particular and focused on these issues than a lot of state courts who'll give second, third, and fourth bites of the apple. So you can get some really good case quotes out of your federal jurisdiction, which are appropriate to be cited in your state court case. Now, the reason that this particular topic is significant is because on December 1st, 2015, the rules were changed. The Federal Rules of Civil Procedure, Rule 26, was changed. And as far as I can tell, most lawyers ignored it. So, the first sign of a problem, if you're using your standard pre-December 1st, 2015 objections to discovery, chances are you can get sanctioned by a defense firm. The number one way you know objections are proper or improper is if it says reasonably calculated to lead to the discovery of admissible evidence. That's the phrase that we learned in law school. That's the phrase that we cite before judges for the last 30 years. It's gone. They eliminated it from the rules. Rule 26B1 is changed to eliminate the phrase reasonably calculated to lead the discovery of admissible evidence. And the new phrase is relevant to any party's claim or defense and not proportional to the needs of the case. So let's talk about Rule 26B quickly. So 26B1 says proportional to the needs of the case. Proportional considers the importance of the issues at stake in the action, the amount in controversy, the party's relative access to relevant information. And by the way, if I'm going too fast and you can't write it all down, if you just shoot an email to Kim White, Case Metrics, great folks. We use them all the time for our case verdict research, and they're just so helpful. If you just shoot her an email, or you can shoot me an email directly at adams@truckwreckjustice.com, I'll send the whole PowerPoint. It'll have the sites and all this material that I'm reading through for you.
Hey, and Morgan, I was able to get the presentation too. So if you can just tell me where you are, then I can help you out.
That would be great. I'm on slide 8.
All right, slide 8. Let's go back. All right, what's the title of the slide?
FRC P26B, Discovery Scope and Limits.
All right. I think I'm getting there. Yes, there we go. There we go. We're here.
Okay.
Okay.
So we left off at the parties' resources, the importance of discovering and resolving the issues, and whether the burden or expense outweighs its likely benefit. And so if we know what's proportional and we know it has to be related to the claims and defenses, and that part we'll get into it a little bit later, but it's really important. If you are doing your standard notice pleading, we were hurt, you did it. The defendant can likely say that your discovery is beyond the claims and defenses in the case, or the claims in the case, and you can be restricted on your discovery. By the same token, if the defendant starts to do a fishing expedition and they haven't alleged an affirmative defense, you've had your motion to strike improper affirmative defenses, they don't get to do a fishing expedition anymore. So it works both ways. Plaintiffs are going to take it on the chin, though, because we normally find a lot of our smoking guns in discovery, and the federal rules have narrowed that down. So what is a proper answer to written discovery? You've got to have responsive, full, complete, and unevasive answers. They cannot limit your answers to matter within your own knowledge and information, if that's a 30B6. You have to reach out, if it's a corporation or a person, to people under your control. And if you don't have it, you have to say you don't have it. So that's critical. For people in the South, the federal courts in Florida have a lot of really good language. They've been dealing with a lot of discovery issues for years, and their case laws that's developed is probably the best if you're looking to compel in the South. So what is a proper answer? Again, it's got to be true, explicit, responsive, complete, and candid. And an objection has to be with specificity. And this is really, really crucial. You'll see the word specificity pop up all over the place. Pops up in the committee notes to the Federal Rules of Civil Procedure, pops up in all the case law. If you are not specifically stating what the problem is, you're going to have an issue. All right. Mary Ellen, we're moving on to objections must be specific.
Got it.
So here they overruled an objection because, again, the defendants failed to state with specificity the grounds for objecting to the request, including the reasons. So it's not enough that there's an objection. There's got to be reasons explaining why. All right, next slide. And it's got to be relevant. And it means germane, not competent or admissible. So that's still luckily pretty much the same. But relevant, if we move on to the next slide, is governed by proportionality. Okay, if it's not proportional, it's merely stating that a request is not proportional to the needs of the case without further specificity is a boilerplate objection. This is specifically set forth in the committee notes. So you've got to go to the rule, go online if you don't have all of the committee notes, go all the way down to the 2015 amendments and take a look. And it's got to be just saying it's not proportional is wrong. In order to say it's not proportional, you have to have specific facts, usually by affidavit. And you've got to explain everything to the court in your objection so they understand what was improper and what was not proportional about the request. All right. So again, a discovery question is not proportional if there's no outer limits. And so again, when we talk about our pre-2015 requests, which tend to lack specificity, and our subsequent request for discovery, which should be very specific, a phrase like including but not limited to is prima facie improper. So if you see in your normal standard discovery that you send out, phrases along the lines of including but not limited to, or if the defense sends you their standard discovery with those phrases in it, they're no longer proper in federal court. Now, if we go to the next slide on proportionality, again, I said before, the advisory committee notes 2015, a party may not refuse discovery simply by making a boilerplate objection that it's not proportional. If we go to the next slide on the Sixth Circuit, proportionality is a real big deal. It's just starting to come into play. Here's the Sixth Circuit this year. It says it's the power and the duty of the district courts to actively manage discovery and to limit discovery that exceeds its proportional and proper bounds. I want you to think about what that means in the hands of an evil judge. If you give them any room to run with this, you may find that the judge exercises a duty to limit your discovery. If it's overly broad, he'll just say, nope, you're not getting it, and you're done. That's my duty according to the Sixth Circuit. All the other circuits are adopting this philosophy. Now, if we go to the next slide, burden. It's clear that the burden on resisting discovery is always on the defendant. However, when you're moving to compel, it's the plaintiff's burden to explain it initially. So you've got to show that it was proportional and reasonable. I'm going to skip the slide that says effects of signatures. The attorney says when they sign that that their objections are proper. And I think that some of the federal courts will actually enforce that on the defense attorneys. But if you're not getting signatures on your discovery, that's a real easy fix under Rule 26 G2 when you combine it with 33 B5 of the Federal Civil Procedure. So if there's interrogatories, they have to be signed, and they can't have long boilerplate, I signed these that were prepared by my attorneys, and my attorneys tell me that these are my answers, but I don't really know if they're my answers because all the wording is my attorneys. That's completely improper. You can move to compel. You're entitled to a straight out signature from the person that is turning the interrogatories in. Okay, this is a pet peeve of mine. If we go to defendants don't have to go first, 26 D3 B says discovery by one party does not require any other party to delay its discovery. You can go first on all the discovery. You can notice the defendants first for discovery. There's no rule that says, oh no, wait, we have to get your client in first. That's not the way this works. It's the way the defense likes to play the game, but that is not the rules of the game. They are trying to create their own rules. All right, let's move on to privilege logs are mandatory. Privilege logs 26B5 are mandatory. You got to describe the nature of the documents withholding. If they're not disclosed, you got to have something. Now, for plaintiffs, we normally don't have a lot of privileged material. Create it. And here's why. Get a statement from your client that says the wreck was not my fault. Write down everything that you'd want to see from the defendants as a privilege log, including, people copied, the date, who it was to, who it was from, and even if it's disclosed later on, you don't care about it because it says the wreck is not my fault. But what this does is it shows the judge your clean hands. You can now attach that privilege log when you're moving to compel a defense privilege log and say, Judge, we'd like the defendants to provide us a privilege log just like we gave them, see attached. We have clean hands, Judge. This is what we've done. They should do the same thing. And having that example there in the format that you want your privilege log in is a marvelous thing, because all of a sudden you get real privilege logs back from the defendant if that's what the judge orders. And if he's got something he's looking at, you can much more likely get him to just adopt it as the order of the court, since that's what you did and you've shown the judge that's what's proper. So I try to have my clients, I try to create a privileged document in all of my cases. I describe it, and then I send it over to the defendants. It'll say attorney client privilege and work product. And then away we go. Now, when they come back and they claim privilege and I don't have a log, I've got a leg to stand on and something I can show to the judge as to what needs to happen so I can actually see what the defendants are withholding. Go to the next slide. Understand that the privilege log is actually a fallback, because in many jurisdictions, failure to provide privilege logs equals waiver of the privilege. Next slide. All right, so we get to the objections. What are the proper objections? Again, specificity. If you don't state the ground, the basis is typically waived. All right, when we go, again, we go to FRCP 34 for request for production documents. It's you got to have specific grounds, including the reasons, and describe specifically and see the responsive materials are withheld. The courts are really tired of the phrase, notwithstanding the prior objections, we answer as follows, because all the courts recognize that means you don't know what you have and what you don't have. So that phrase has been taken out behind the back and shot and riddled and shot again and thrown into the refuse heap of history. So if you are using the phrase, notwithstanding the prior objection, the plaintiff answers as follows. The judge is likely to take you out back and teach you a lesson. Okay, again, if we go to the committee notes on Rules 2015, again, specificity. And it's got to be clear. And if it's not clear, you're in trouble. If we move on to the next one, the 1993 amendments, a party must notify the other parties if it's withholding materials. If you fail to tell folks that you're withholding materials, then you're subject to sanction. And this is getting enforced more and more and more. Next slide, subject to and without waiving general objections. Here's the case that says it's completely improper, as we talked about before. Next slide, boilerplate objections. The all caps in this slide is from the court. The judge put that in. And as we all know, all caps is shouting in our emails and in our texts. And the judge was very clear in this case that he was shouting, no more warnings. Boilerplate objections will place counsel and their clients at risk for substantial sanctions. I've got a case where the defendant and the plaintiff both used the same exact response. And one of them moved the court to compel. And it was a boilerplate response, and the court sanctioned both of them, even though they adopted identical responses. So don't get smart with this stuff. Judges are really tired of these boilerplate objections. The next slide, again, great quote. The idea that boilerplate in some talismanic way preserves an objection is fallacy. It has been fairly styled an urban legend. Next slide. A lot of times you'll get discovery responses, and I used to do this myself, where there's like 20 points of general objection before you get to any of the answers. And this judge assembled a lot of cases and says the general objections serve no purpose other than to waste the reader's time. Now all defendants' general objections are overruled. So if you do have a general objection at the front, then you need to specifically adopt that objection when responding to a specific question. Say, see above as to time. See general objections as to time. And that objection may be, we're limiting all of our responses to 3 years on the following basis, unless otherwise stated. In which case, that would be a specific objection that would be adopted in response to a defendant claiming each and every, all, or some of those phrases. List all witnesses that have any matter that pertains to this case. Well, with a plaintiff, that's any person that's ever seen the plaintiff before would be able to testify as to whether or not they had abnormal conditions prior to, from birth, from the doctors and the nurses, all the way to the moments before the wreck, anyone that saw them at a grocery store. I mean, it's a ridiculous request, but I see it a couple of times a year. And anyone after that's ever seen them walking down the street, did they wince in pain? Did they not wince in pain? With every step. Again, it's overly broad, and the courts are going to slam you for it. All right, moving on. The next slide, subject to and without waiving the foregoing boilerplate objections, fails the specificity requirement. Now, the Liguria Foods case from Iowa that I cited before and right now is actually one of the more famous cases on boilerplate discovery. It's now been cited, I believe, in 18 or 20 states, and almost and quite a number of circuit courts have adopted the language from this case. So it's a good read, and it gives you a real clear idea of how tired the federal judges are about dealing with boilerplate objections. If that's something that you do, and something certainly that I did, you need to stop it. The effect of a general objection is waiver. And again, here's some North Carolina and Ohio cases. And, the Fourth Circuit and the Sixth Circuit are not hotbeds of liberality when it comes to anything. And they're very clear that they're tired of dealing with bogus discovery disputes. All right. Again, general objections, if we go to the next slide, do not work to create a privilege. And you can't just yell out privilege. You have to state a little bit more specificity. I'll move on to the next one. Next slide. Again, we've got waiver. And it's well settled that a party's failure to file timely objections to request production of documents constitutes waiver. And again, it's got to be a specific objection and not a boilerplate objection. Boilerplate objections are ignored. Next slide, vague and ambiguous. The term vague and ambiguous has to be explained. Okay, why is it vague and ambiguous? If they're not explaining why your request is vague and ambiguous, they lose. That's an improper objection. Next slide. Go find it yourself. Here's 1,000 pages. We're not going to tell you where your response is. That's a completely improper request. Here's a Kansas case on point. Next slide. This one I absolutely love because there's a requirement for an affidavit or good evidence to show that something is unduly burdensome. They can't just say it's unduly burdensome. They've asked for materials. Somebody's got to come in and provide competent evidence to say, this is going to take me 3 years and $400,000 to put together, and we've never done it before. We don't even know where to start. We'd have to hire an expert. Next slide, possession and control. This one is also interesting, and I think it impacts plaintiffs as much as anyone else. I've had a habit of saying to defendants, you can go to all of my doctors, my clients' doctors, and subpoena them, or we can agree to an agreed order. But if we do the agreed order, it's going to have some provisions in it that are pretty favorable to me. The possession and the control series of cases would likely say, because the plaintiff could request the documents from their doctors, that the plaintiff is in possession and control of those documents and would have an obligation to get them and turn them over. This is all based on who has a legal right to obtain the documents. And for the most part, it's the defendants, but the plaintiffs get burned if they get uppity on turning over employment records or medical records where they would be deemed to have a legal right to obtain them. They would have possession and control under the federal law. All right, next slide. I do a lot of trucking. That's all I do, frankly, and FedEx has like 10 different companies. If you haven't had multiple cases with FedEx, you don't know the joy that you're missing. Here's one great case out of Missouri that said that the sister company materials were under the possession and control of one of the other FedEx companies, FedEx Freight, from FedEx Ground, and they required turning over the materials from both. So that gives you an idea of how close the courts take a look at the issue of possession and control. Any and all facts we talked about before is on its face burdensome. Tons of cases covering this. If you're saying any and all facts, you need to go back through your discovery, weed it out, and start using some specificity. Next slide. Relating to, concerning, and pertains to are also overbroad. And it's tough because we don't know the language that the defendants are using in their cases. So again, I do trucking. In some companies, they'll have a hard break. Other people will call it a hard stop. Other people will call it a panic stop. And these may trigger warnings from the electronic black box systems to the dispatcher and the safety department. And I want those to see what kind of driver we have. Well, the problem is I can't just put, relating to hard stops or hard braking because it may be a different term. So you've really got to start thinking about how you're going to get the information that you want. And it may be, something that please provide all of the deceleration events created by this truck and this driver, whether they're called panic stops, hard brakes, hard stops, or any other term. And that may make the federal judge a little bit happier. All right, next slide. Meet and confer. This has gotten to be a huge issue in federal court. The meet and confer has to be conducted in good faith. And there's an Eastern District of Tennessee case. I know the lawyer involved, and I can imagine what happened. He got a huge slew of boilerplate discovery, called up and said, hey, this is ridiculous. Fix it. And they said no. And here we go with the judge, and the judge really wanted to give him attorney's fees for having to file this. But because he hung up immediately after the lawyer said no, what you have is the plaintiff's counsel had a 5-minute telephone call addressing only a single interrogatory, did not meaningfully discuss with the defendant each discovery request and dispute, and the appropriate way to address boilerplate objections to seek waiver or sanctions if the dispute is not resolved after a good faith conferral. The plaintiff did not confer in good faith, even though the court noted there's a huge amount of boilerplate. which was improper. But what it cost the attorney was the ability to get attorney's fees. So I'm going to come back to that in a minute, but I want you to think about going through every single one of the questions that you are saying were improper and getting an answer, or at least addressing them in some form or fashion, and then sending out a confirmation letter. And I'll get to the confirmation letter here in a minute. Okay, next slide, evasive answers. An evasive or incomplete disclosure is treated as a failure to disclose, answer, or respond under 37A4. And so unless you're saying we don't have it or we don't know if it exists, and we can't find it, you've got to have a specific objection. The same is true of the defendants, same is true of the plaintiffs. You can't play games in federal court with discovery. And so here is the, if we go to the next slide, the meet and confer. There's got to be a certificate of meet and confer prior to doing a motion to compel on any discovery response under 37. And you've got to have an actual certification and 2 performance. And the performance is where a lot of people fall down. You've got to have a good faith request to try to get things resolved. So if we move on to slides, I believe it's maybe 48, meet and confer letters. Mary Ellen, are you there?
Got it.
Okay. So what I like to do is send a confirmation letter after the meet and confer that confirms that there's no issue as to the terms. Everybody understood the words. Everybody understood what the words meant. The issues as to the scope, the time frame, or the department, where the documents are going to be found, or where the issue has been narrowed down. Relevancy has been resolved. All the requests are proportional. Maybe there's a dispute about proportionality. I set it out. And under the new 30B6 meet and confer requirement, which went into effect December 1st, 2020. So if you're doing a 30B6 deposition in federal court now, note that the federal rules have changed December 1st, 2020, and you have to have a meet and confer prior to doing your 30B6 deposition. The advantage of sending a letter with this is that it can't now come up in the deposition with 5 pages of objections to notice topics. The meet and confer eliminates all of that. And so that was my last slide. I promised Kim and Mary Ellen that I'd finish in 45 minutes. And so I went through a little bit fast because I was behind with technical difficulties. I've got more slides behind this if we don't have any questions, but let me turn it over to Kim and Mary Ellen and see if we have any questions.
Okay, I think we have answered the questions that were case metrics related. I think one of the recurring questions I was getting through Q&A and in my email during your presentation is people wanted to know if they would be provided a copy of the PowerPoint. So we will email that to everyone afterwards. I can see how this could be a really helpful resource to have in a really concise way. So we will be providing that. Also, for those of you who joined us late, you were inquiring about whether the recording was going to be provided. As soon as this is posted to the Case Metrics YouTube channel, you'll get an email with a link to that as well. So you can have this to review in its entirety and to save as a reference for later. I don't see other questions right now. Let me check the chat to see if anyone has put anything in there. Let's see, don't see anything. So if there are no other questions.
Well, Kim, let me just, can I get Mary Ellen to click through on 2 or 3 more slides?
Absolutely. Let's go ahead and put up more of your content.
All right, hang tight. All right, we're ready.
Okay, so the next slide says 11th Circuit, Alabama.
Let's see. Objections to written discovery. Yes, 11th Circuit, Alabama. Yep.
There you go. So I just put a couple of slides together for the 11th, 6th, and the 4th Circuit, sort of the southern states. Kim, you told me that was the most of the folks that would be online. And I just wanted you to see, here's a 2020 case that, again, vague, overbroad, not limited in time and scope. It's too general. All the objections were overruled, and the cases went on to go to say that they may border on a frivolous response to discovery requests. Alabama, once again, very conservative jurisdiction, and the 11th Circuit, is fired up about these issues. So be very careful with your responses, but don't allow the defendants to get away with sham discovery responses. They actually should be meaningful. Next slide.
Can I interrupt you just a second? Because we do have a number of questions that just popped up. Is this a good time, Morgan?
Sure. Yeah. No.
Okay.
All good.
Sure. Christine King. Hi, Chrissy. She's asking, are you saying that the client now has to sign the discovery responses or just through a verification?
Well, I'm not sure I understand the question because a verification is the client signing the discovery responses. But the client has to say, these are my answers. And a corporation has to say, this is the knowledge that's known to the corporation. It can't be, I've gotten, 4 paragraphs of qualification language in the assigning of the interrogatories. It makes it completely worthless. So when you sign a verification, the interrogatories have to be signed by the client. Requests for production are signed by the lawyer. Requests for admissions are signed by the lawyer. But there's a responsibility as the attorney to have proper signature, proper duty as an officer of the court, get these things signed properly.
Okay, thank you.
I hope that answered the question.
And LeBaron Boone has asked if they can get an example of a detailed privilege log. Is that something that you can provide afterwards that we can send along with that email to the attendees?
I can probably provide that next week. I'm not going to be able to provide it tomorrow.
Okay, I understand you're about to speak at another event. So if you'll put that on your to-do list, and we'll follow up with you to get that so we can share that with the attendees as well. Molly Glover has stated, I've seen many instances lately of defense counsel dumping thousands of documents, many of which are irrelevant. And then it just says, and then. So in light of your earlier comments about that, I'm not sure what Molly's question is, I guess. Is that inappropriate under the new rules?
They can, so part of what I request is that everything be bait stamped, but regardless of whether it's bait stamped or not, the rules require, and frankly have always required, that the defendant state the documents are responsive to which question. So if you've got 15 requests for production, they produce 5,000 pages, they have to say more than just see attached Exhibit A. They have to say something along the lines of, pages 100 through 200 are in response to request for production 1. So there's got to be some way that you can figure out what they're related to, or what the defendant is claiming that they provided to you. I mean, I still always get hit. We've given them 300 pages of discovery, Your Honor, and they're still asking us for more information. And the 300 pages of discovery was a 50-page multi-tractor trailer police report and a 250-page insurance policy, or maybe some photos from the police. So I've actually gotten 0 pages of discovery from the corporation, and that's the sort of stuff that's improper and I think grossly misleading to the court. But I do request, I have full Adobe I think it's the greatest thing since sliced bread. You put all of your discovery documents in folders, and then Adobe will mark each folder with numbers automatically when you print it. And so we send everything out bait stamped, and we request everything comes in bait stamped. If we get it in and it's not bait stamped, we scan it in, put it in a folder, we bait stamp it, and then send a letter back saying, we've received X number of pages. Here's a copy, bait stamp pages 1 through 2000. Because I want to know exactly when they say we've provided something to you, I want them to be able to point where, what page number, because too often, at least in the old days, I would get into court or in a deposition, they're like, oh, we gave you that. And they pull out some smoking gun that I'd never seen before.
And I think that sounds like that's what the new rules are trying to address. I think we've all been there in the old days where you were individually bait stamping thousands of pages and looking for that needle in a haystack. And you can go blind and spend a lot of hours trying to do that. So I think this is a huge improvement. Joseph Kavakis is asking, are there examples of proper interrogatories or objections? Is that something that you would be able to provide later? Or have you actually answered discovery using the new rules yet so that you would have examples of your interrogatories or objections to the other side's interrogatories?
I'm sure I can. Well, I can tell you that I have moved to compel in Kentucky federal court in the Merriweather case, and got an excellent decision from the district court there.
Okay.
And I think that would set forth a lot of the standards and the requirements, and I'd be happy to share those materials, the motion to compel. And by the way, in that order, there were paragraphs where, even though I talked to the defense attorney like 10 times, I didn't have one more meet and confer and put my certification down, because these were court-ordered talks, and we've been informing the judge that we've been meeting and conferring and trying to work it out. And we had multiple judicial conferences over our meet and confers, but I missed putting the certification in when I moved to compel, and the court spent like 2 pages. It seemed like forever yelling at me for not putting that in before it said, since we were party to the phone calls, and we know how hard they've been working to try to get this out, nothing would have changed, and it all worked out. But it's a big deal.
We've got a question from Gloretta Hall. Hi, Gloretta. I hope you're well. She's asking, if responses to discovery are untimely, are objections waived?
Depends on the jurisdiction, and and it also depends, I think, on the type of discovery. In federal court, if requests for admissions are untimely, they're automatically deemed admitted, and the person that missed the deadline has to file a motion to withdraw the admitted admissions. And if you're in a motion for summary judgment, it can be fatal at that point in time. With the other discovery, because there's this meet and confer requirement, maybe not. I don't think most judges care about one day, but the further you go through, the bigger an issue it is. The more time that's passed once they're due. You should always be asking for additional time if you need it from the other side, because it does get to be a big deal. And there's certainly a number of judges that will deem all objections waived. There are other courts that will not go that far, particularly if there's a good basis for being delayed, and they'll look at how timely it was. But yeah, absolutely. There are some federal courts that take a real dim view. I've been in the rocket docket in Virginia, Eastern District, where as soon as you file, you've got a court date in, I think, 3 months, 6 months. It was astonishing. I think they would deem it waived.
Yeah, that's
not an issue in my case, but it's going to depend on the jurisdiction.
All the more reason to triple docket those reminders. for sure.
And-
When I was still working in a law office, we would have a partner, associate, paralegal, and any secretaries on the team. Just in case somebody's out sick, something happens, there's any number of backups in place. So we're just not taking the chance. Paranoia serves me well in these situations.
And along those lines, when you're doing your scheduling orders, make sure that you put in a date that deals with when your discovery must be served. Too often I see a written discovery cutoff, but then the local rules will say something like, all written discovery must be served 30 days before the written discovery cutoff. And then the objection is because they didn't have the mailbox rule. They didn't have an additional 3 or 4 days. And all of a sudden, the calculation gets really hard. Whenever I'm in one of those situations, I create a hard date that says, all written discovery must be emailed by this date, served on opposing counsel by this date. Something along those lines that is different than the normal just cutoff date, so that I can actually dial it in the computer system and we don't have to do math. I just want to have one hard date, and we don't have the math problem about the mailbox rule, and did it have to be sent out prior to 30 days prior to, plus the mailing, not including the date of the event. The time rules and the federal rules of civil procedure just a pain to deal with.
They are indeed, and you can't be careful enough, for sure. It's nice to have a number of backups in place, for sure. We have another question from an anonymous attendee who's asking, is there a motion or brief that you use or have filed recently which includes citations to these federal cases that you would be willing to share, how the judges in federal or state court ruled on your motions to compel, involving the boilerplate or blanketed objections? I think you made reference to one earlier, that if I was hearing you correctly.
Sure. So some of the cases, if we went through, there'll be one, here's a Florida case from 2021 on motions to compel. So there's, proportionality, again, Florida, Georgia, Tennessee, just looking at the cases, there's a bunch of them. So there's a Sixth Circuit quote on proportionality that says it's now the duty of the district courts to actively manage and discovering to limit discovery that exceeds its proportional and proper bounds. And that's the Sixth Circuit. So they're telling the judges to do this. I will, Kim, if you'll just remind me to send over the Meriwether brief in order, that's under the new rules. And it should give a lot of the information, but the slides that we're going to be sending out have the most recent case law, and all of this is just working its way up now. So it's really not been a big issue in my experience for until the last 2 or 3 years, and it's slowly starting to circulate around. But it's becoming more and more apparent that the plaintiffs are often the ones that are violating these rules and using the old discovery. So when you guys get all of these slides, most of the slides have case sites, and that should be, again, a blend of Fourth, Sixth, and 11th Circuit cases. And if you need anything, I've got offices in Seattle and LA for our trucking cases, and so we have a huge amount of Ninth Circuit material as well.
Okay, I have a really good question from Kimberly McDonald that I want to try to squeeze in here. She said, if a 30B6 witness is not fully prepared, despite having a meet and confer about the topics, are there any specific changes with regard to sanctions? Is it worth asking? Is it worth seeking sanctions and having a proper witness versus having a corporate rep appear clueless in front of a jury?
it's going to completely depend on your jurisdiction. So there are two sanctions that are common, two schools of thought in the cases. The first school of thought is that is the binding deposition, and it's not that they don't know. The binding answer is they have no answer, right? They never did. They didn't do. And the other school of thought is you get a redo, and you may get sanctions, and they have to pay for your time and preparation. So one of my favorite quotes is, "A deposition is not a take-home exam." You don't. You don't get to just do a deposition and then complete a rata pages, or go back home and prepare them again and say, okay, this one's real. That's not the way these work. And I'd be happy to send you the quote on depositions not being take-home exams. I use it all the time. It's now been adopted. That case has been adopted by just about every circuit. Just be able to put a quote into Westlaw or Lexis and pull that one up. It really depends on what you want. A lot of times, if you phrase the questions right, well, let me back up. If you know the answer to what your jurisdiction does, you can either just agree, on site immediately that they're going to provide somebody new in X amount of days, or you can turn around and ask questions in such a way that when they're before the jury, the company looks really bad if they're going to be bound by their answers.
Okay.
But I really like having them bound. I don't need the monetary sanctions if they've got an unprepared witness, and understand with a good faith letter where everything's been cleared and there's no confusion. Now when you and that's the December 1st, 2020 change to the 30B6 requirement. Now when you have a improper, no-show, I don't know witness, they're really going to be burned, the defendants, because there's no excuses anymore. It can't be we didn't know that they were going to ask these questions, because you've sent a confirmation letter out that said, yeah, you knew exactly what we were going to ask and we discussed it.
There you go. We have one more question, and then I appreciate people being patient and staying on with this a little late, but I think this is a really good one from Joe Kavakis, and he's asking, how do you handle defense responses that repeatedly state defendant further shows discovery is ongoing and will supplement its responses to this interrogatory in accordance with the Georgia Civil Practice Act? I think we've all seen that one a zillion times. So do you have a good response for that?
Well, so one, all that's doing is stating an attorney's ongoing duty to supplement discovery. So the answer is that is a completely proper response, but it's unnecessary because that's your duty as a lawyer. So
you already have to do that.
Right. So the bigger issue is, have you asked them to supplement? So, we're now 6 months into the litigation. We're 3 months away from discovery cutoff, the end of all discovery. It may be worth, a motion at that point in time, say, well, Judge, they put in all these qualifiers saying they were still looking for stuff. I've asked for a supplement. I need these to be removed, or I need them to say, what's going on, but I don't need to be surprised, after the discovery cutoff with all of a sudden with all these new documents.
Yeah, I know we used to diary those forward by the interrogatory numbers or the request for production of document numbers. And we would say, okay, you said that this is ongoing and you'll supplement on these items. So you've already got the individual interrogatory or RPD numbers ready to go. So you can specifically address those in your request for supplementation. So it's good not to ignore, it's easy enough when you're going through and you're reading through all these and you're not getting substance and you keep looking for the substance down the line. But I say it's good to go ahead and diary those and say, hey, this is what you said you would do and you haven't done it.
Right. So we make a habit of going in and supplementing all of our discovery, 2 or 3 months before discovery cutoffs, and asking for the defense to supplement theirs as well, so that, again, we can show that we have clean hands. And we have probably mailed all of the new medical records and updated new doctors to the defense through correspondence or something else. But we make a deliberate attempt to go through all of the discovery, interrogatories and requests for production of documents, and send those out again, just so that we can claim we've got clean hands. We did it the way it was supposed to be done, and judge, look at how they've sandbagged us. And we get a lot more sanctions than most law firms, I believe, as a result of having clean hands, showing the judge that we did it right, and setting the defense up to where they chose not to do what they were supposed to do.
Okay. Thank you very much. I think we have addressed most, if not all, of the questions. Do you have any comments to wrap up, or are you finished with your primary slides?
I will just say that most of this can be done in advance, because now it's all there needs to be a procedure with the meet and confer. So I have my paralegals, as soon as a boilerplate letter, set of discovery comes in, my paralegals have a standard letter that goes out that doesn't even need my direct involvement. And they'll just look and say, these are all boilerplate responses, please remove them. And that letter can go out without me. And then I come back in 30 days or 15 days down the road, and I follow up and schedule a meet and confer.
Right.
I try to decentralize this as much as possible.
Well, it's good that you've got a systematic approach to every element of this. And this was incredibly informative. Guys, be patient with us a little bit. We want to give Morgan an opportunity to get back to the office and pull these documents that we need. As soon as we have all that together, we'll forward it to you in a single email. And we'll also notify you when this recording is posted on our YouTube channel. If other questions arise, all of the attendees have my email address. Morgan, let's put your email address in here in case there are other direct questions for you. May I type that now, Morgan?
Sure. It's adams80ams@truckwreckjustice.com. And, happy to address any truck or bus litigation questions. That's sort of our wheelhouse. And at least with truck and bus defense attorneys, we plan on at least one motion to compel, and most likely 2 or 3 before we actually get serious documents.
Okay, very good. So I have just included in the chat Morgan's email address and mine if you have other specific questions. Thank you so much, Morgan. You have been an incredibly good sport to do this with all you have going on this morning. Good luck with your next few speaking engagements. I know you've got a lot of them lined up. You're in demand these days, but we really appreciate this. And you will be getting, the attendees will be getting an email from us with other information. Don't hesitate to reach out to us to look inside Case Metrics free of charge for 10 minutes. It's one way to look at it for free. And you can reach out to us directly to schedule that for you. And also, we will be sending you an email very soon about our next webinar, which I think you're going to enjoy. Thanks so much, everybody. Have a great week. Bye-bye.
Bye-bye.